Salam sejahtera and good day to everyone. My name is Crystal Chongkai with the matrix number of 07678. Today, I'll be presenting my case review on Toh Siwi and Teddric Jon, which focus on privacy, hacking, and breach of confidence in Malaysian cyber law. Without further ado, let's jump into the facts. The plaintiff claimed that the first defendant have wrongfully hacked into his personal email account, downloaded and printed the emails, and later used them during the Board of Trustee meetings. The plaintiff further alleged that the second defendant have obtained copies of those email without consent and published them to at least five other individuals. Based on this allegation, the plaintiff argued that the defendant has invaded his right to privacy and committed a breach of confidence. He therefore sought a damage and permanent injunction to restrain further publication of his emails. Therefore, the major issue arises in this case is whether the plaintiff entitled right to privacy when the defendant hacked into his personal email account. By considering all facts and evidence adduced in the court then dismissed the plaintiff's claim. First, the court held that there is no evidence to prove that the first defendant hacked into the plaintiff's email account. Second, the court reaffirmed that invasion of privacy is not recognized as an independent tort in Malaysia. Therefore, the plaintiff could not rely on torts law to support his claim. Third, the court stated that nothing in the federal constitution expressly recognized a stand-alone rights to privacy enforceable between private individuals. Importantly, the court applied the equitable maxim, he who comes to equity must come with clean hands. The plaintiff himself had sent the offensive and humiliating emails about the defendant and the hospital to his friends. As such, the court found that his conduct was improper and equity could not assist him. The court also ruled that there is no breach of confidence because the emails were voluntarily sent by the plaintiff to the third parties, making them no longer private or confidential. From the case, we can know that the current status of right to privacy in Malaysia is still ambiguous. There is no clear provision showing that how to seek the rights to privacy. The current Malaysia court only rely on Beatrice's case where individual could not seek right to privacy under federal constitution as federal constitution is a public law. Although the case of Lee If Paul and Genting Malaysia mentioned that federal constitution recognize right to privacy. And the case of Sivarasa provides that violation of fundamental rights give rise of action of damages. However, it is still consists of different opinions where Atian case provides that proceeding under constitution can be brought under private law. Tivavati case provides that common law mitigation of damages should not be applicable to human rights violation. These decided cases further affirm that the right to privacy is unsettled in Malaysia. Thus, it is recommended that the Parliament shall come up with a clear provision upon this matter by considering the position of court proceeding and the rights of certain groups of people such as media, online users, and officers to prevent conflicting in judgment and uphold the protection to privacy. So this is end of the video. Thank you for watching.